Hello everyone and good evening and welcome to NLTI. This is Mansi Mankotia. I am going to be your guide, your friend and your mentor for this live session today. So I hope all of you are preparing well for CLAT 2027 and I hope your preparation is coming along good so far. Today in this session, in this video, we are going to understand one very important component of the CLAT legal reasoning section, which is your constitutional law. So now if you have observed the PYQs or even if you haven't observed the PYQ, something that I would want to share with you is that a lot of legal principles that are around constitutional law are tested frequently in the CLAT section. In fact, one of the most tested areas is constitutional law. You will find a lot of questions which are going to be around basic provisions of constitutional law. So one thing about legal reasoning is that of course you do not have to know everything about all the laws, right? It is not testing your legal knowledge, but if you are familiar with some concepts, it's going to be easier for you to read the passages, to understand the passages, and finally to answer the questions. So in this session today, we are going to understand some really frequently tested areas, frequently tested topics of constitutional law so that you have basic familiarity with all the concepts and so that you can finally kickstart your preparation well. All right, so let's get started. So, like I've already mentioned, this is not an exam where you have to study a lot, right? But if you are studying things which are just right, that's going to be enough. Okay. Now, constitutional law is divided into multiple aspects. There are going to be articles, right? Articles which is going to tell you what are the different provisions that we have, different rights, different duties, how the government has to function, everything, how every organ of the government has to function, different rules and regulations around the same have been given to us under the constitution. Then there are landmark cases. See, constitution in itself was made back in 1950 and this is 2026. So clearly we're not using the same constitution, right? There have been a lot of changes, there have been amendments, and when the constitution was made back in 1950, a lot of things were there which were probably not clear, right? So now it is the Supreme Court of India's responsibility to give meaning, to give interpretation to those vague or ambiguous provisions. For the same, there are different judgments, right? Through several judgments, Supreme Court of India has basically explained how a particular function has to work, what is going to be a meaning of a specific term or a specific word in the constitution. So there are different judgments and all these judgments are really relevant, really significant in the constitutional law. And then there are doctrines. There are different doctrines. Doctrines are like different legal philosophies, legal principles only, based on which the Supreme Court functions. So, right, all of this in total, it makes the constitutional law what it is, right? So now let us understand what is there, what are the most frequently tested areas. So first of all, there is the preamble. So if you know preamble, it is the introduction to the constitution, but it is not just limited to the introduction. It is not just about introducing the constitution. The preamble, it basically conveys the intention and the philosophy of the entire constitution. Now, if you are if you have ever read a constitution, even if you haven't read constitution, if you have ever read any NCRT book also, right, you will find that in those NCRT books, mostly the first page is about the preamble, right? Now the preamble, it tells us what is the intention of the constitution makers. It also tells us what is the intention of the constitution itself, and as a citizen of India, what all different privileges you might get, right, based on what the entire constitution is made. So now, if you have read the preamble ever, you will see that the constitution, the preamble, the opening words of the preamble are "We the people of India," and the closing words of the preamble are "Give ourselves this constitution." So one very important takeaway from this is that the constitution is something which the citizens of India have given to themselves, right? So we, the people of India, have given ourselves this constitution. Now, nowhere in the constitution it has said that who is giving the constitution to whom and that the constitution is going to be the supreme. That is also not mentioned everywhere. But It's the preamble which tells us that this is the constitution that we, the people of India, are giving ourselves. Now, when originally the constitution was made, right, there were a lot of things that were not part of the constitution. For example, words like socialist, secular, and integrity. Right now, these words were originally not part of the preamble. These were made part of the preamble from the 42nd Amendment. Right. So now I have seen a lot of times the questions around triple SDR being tested, right? So if you know all of this, it's going to be much easier for you to actually understand and answer questions around the preamble, right? Now, yeah, one also important thing that a lot of times students ask me that whether preamble is considered part of the constitution or not, right? So in Keshwananda Bharati versus State of Kerala, it was held that preamble is the part of the constitution, right? And the principles that are given in the preamble are the founding principles, and based on that, the entire constitution has been made. So it is the foreword of the constitution, but it is still the part of the constitution. Okay. Then most important are the fundamental rights. So Constitution of India is divided into multiple parts. Right? There are multiple parts to the Constitution of India, and there are schedules as well. Now, part 3 of the Indian Constitution, it talks about the fundamental rights. Right? Now, fundamental rights are in the part 3 from Article 12 to Article 35, right? And all these articles, they provide us some very different meaning and different type of rights. So in total, every citizen of the country has 6 fundamental rights, okay? And now this is something which has been discussed in detail in part 3 of the Constitution. So now starting from Article 12, right, which defines as the term state. You will find this word being mentioned in the entire part 3 a lot of times. And um, first of all, now what exactly is the meaning of the state? Now, because it is being mentioned so many times in the entire part 3, the constitution makers, first of all, have explained that term in detail in Article 12. Right? So, Article 12, it says something really simple, that the term state is going to include three things: the parliament and the central government, right? The state governments and the state legislative assemblies, local and other authorities, right? Now, that is something which basically means anything that is similar to functioning of a government, or is run by government, or is operated or managed by government. Now, that is going to be considered as state. So, this is something which Article 12 basically explains to you. Now, then we have Article 13 of the Indian Constitution, which says something really simple. It says that if the parliament, or if the lawmakers, they make any law which is inconsistent with the fundamental rights, which means it is a law which is against the spirit of constitution, against whatever has been given in the constitution, is against the fundamental rights of a citizen, then the judiciary has the power to struck that law off under Article 13. So these two provisions, they tell us how important are the fundamental rights. And then in detail, let's understand some really important fundamental rights. First is Article 14, which talks about right to equality, right? Which is also equality before law, which says something really simple but really important, that everybody is equal in the eyes of law, and there is nobody who is above law, right? So there is always going to be rule of law. Whenever a law is being made, it has to be followed, it has to be adhered by all, by every citizen, even non-citizens of a country, in the equal way. So if ever a crime is being done, right, if it is being done by a normal, regular citizen, or maybe by the Prime Minister of India, the treatment is going to be the same, the punishment is going to be the same for both of them. Right? So there is right to equality, which is given to us under Article 40. Then something really important, a lot of times, a lot of questions which you will find around is going to be from Article 19, which gives us right to freedom. Now, that is a very broad term, but Article 19, it defines it really concisely, and it gives us 6 type of freedoms, right? So as a citizen of India, you have 6 type of freedoms as your fundamental right. Now, what are those freedoms? First of all, there is freedom of speech and expression. You can express yourself the way you want, be it verbally, be it in written form, be it through gestures, right? Be it through print media, online, any way you want to. You have the right to um, express yourself freely. Then, right to assembly. Now, assembly here means that you can assemble. Now, if you want to assemble to protest against something, or maybe it's a strike, or if you are just assembling, you just, getting together, the constitution allows you to do so. The restriction here is just one, that you cannot assemble with arms. So if you are assembling peacefully, that is something which is absolutely allowed. You can definitely do the same. Then you have right to association, right? You might have associations or unions, right? You can make associations, you can make unions. You might have heard of labor union, trade union, truck unions, right? All of it is allowed. All of this can be done, and the constitution gives us the freedom to do so, right? Then right to movement. As a citizen of India, you can go to any part of the country, right? Nobody's going to stop you for anything, right? If they do, then it is against your freedom. And then finally, right to choose your profession. You can pick any trade, any business, any profession that you want to pursue. It is not something that nobody can restrict you from doing so, okay? All right. Further, some most important article that we have, most important fundamental right that we have, is Article 21, which talks about right to life and personal liberty. Okay, most of the times there are questions from this article, so it is one of the most important, highly tested article, highly tested fundamental right. And it talks about something really simple. It says that every citizen of the country has right to life and personal liberty, and it is also a fundamental right which is available to non-citizens, right? So if any foreign national comes to India, and if he or she has a threat to his life, right, then he can also claim this right of right to life and personal liberty. Okay, now how it actually functions. So the bare provision or the constitution talks about something really simple. It says that no person shall be deprived of his life or personal liberty except according to procedure established by law. Only this much is something which the constitution is talking about, right? Now it's too broad, it is not making a lot of sense. So in that case, what is important? That an interpretation for the same is required. So the interpretation, like I've already mentioned, it is the judiciary's job to do that interpretation, right? So judiciary is going to decide what is going to be the meaning of a specific word or a specific term, or how it is going to function. So through several judgments, hundreds and thousands of such rights have been made of Article 21. For example, in Menaka Gandhi versus Union of India, right to travel abroad was recognized as part of a fundamental right. In K.S. Puttaswamy versus Union of India, right to privacy was recognized as part of Article 21, right? Navtej Singh Johar versus Union of India, right to dignity was recognized as part of Article 21. And this way, there are thousands of such more judgments where these rights have been recognized, and this all of this are part of Article 21. Now, it is often said that this is the golden triangle of Indian Constitution is Article 14, 19, and 21. 14 is talks about right to equality, 19 talks about right to freedom, and 21 talks about right to life and personal liberty. And together, these three principles, these three fundamental rights, they make the golden triangle of the Indian Constitution. Now, after that, another really important article, another really important fundamental right is right to constitutional remedies, which is given to us under Article 32 of the Indian Constitution. And you will see it being tested a lot of times at what is called the heart and soul of the Indian Constitution, as per Dr. B.R. Ambedkar. So that is always going to be Article 32, right to constitutional remedies. Now, what does it say? It says something really simple. It says that if ever state violates any of your fundamental rights, right? Now, what is state? State is something which has been explained under Article 12. Parliament and central government, right? State government and state legislative assemblies, and your local governments and other authorities. That's going to be state. Now, it says Article 32 says that if ever state violates any of your fundamental rights, then you have a right to get a remedy for the same. You have the right to get justice for the same, and for the same you have right to constitutional remedies, which is also your fundamental right. So if ever you get any of your fundamental rights violated, then also you have a fundamental right to get justice through right to constitutional remedies, which are given under Article 32. Now, under Article 32, there is a concept of writs, right, which we are going to discuss shortly. There's a concept of writs, and through writs, any person can get justice and can get a constitutional remedy under Article 32. They can directly approach the Supreme Court and can seek justice. Okay. Now, how it is done, it is something which we are going to discuss shortly. Then another really important part of your Indian Constitution are the DPSPs, which are Directive Principles of State Policy. Now, that is something which is given to us under Article 36 to 51, right? And what are DPSPs? If you will read it carefully, it says Directive Principles of State Policies. First of all, the word directive, it signifies that these are some directions, right? These are some suggestions, some directions that, okay, probably the government should do these things. So these are directive principles. The purpose here is to direct the government, to tell the government that, okay, you have to work to achieve a certain goals. So now if you are a student and if you're preparing for CLAT, then you probably have a goal that you want to go to NLSIU, right? You have a goal. Now you are going to work, and probably your mentors and your teachers and your parents, they are going to give you instructions and directions so that you can achieve the goal. Same way, if the government has to function, it also has to achieve some goals, right? Now, to achieve those goals, the constitution is giving them some directions, some instructions, right? That is something which has been given under DPSPs, and DPSPs are under Article 36 to 51. Now, like I've already mentioned, the purpose here is to give directions and suggestions to the government. Now, DPSPs, they are, what is the basic purpose here is to make a society which is welfare oriented, right? It is, there are different type of goals that have been made part of DPSPs, which are not your fundamental rights. So see, whenever originally the constitution was made, not everything could have been made a fundamental right. There are a lot of other things which are important for a citizen, but still are not fundamental rights. For example, right to work or equal pay for equal work, right? So now that is not something which can be made a fundamental right, but these are important things. So all of these are made part of the DPSPs. Now, the government has to work, has to make laws, policies, rules to achieve those DPSPs. I said one thing, that if ever your fundamental rights get violated, you can directly go to the Supreme Court using Article 32. But if ever any of your DPSP gets violated, now what are DPSPs? Like I've already mentioned, you have several DPSPs like Uniform Civil Code, free legal aid, protection of environment, protection of wildlife, right, protection of culture and heritage of India, and much more, right? We have a lot of fundamental rights. Respecting, now, okay. So, a lot, sorry, we have a lot of DPSPs. Now, if ever your any of your DPSP gets violated, right? Then in that case, you cannot go to the court saying that my DPSP is violated and I need justice for the same. You can do that for your fundamental rights, but you cannot do the same for your DPSPs. Simple. Then we have fundamental duties. Now, as a citizen of the country, you have some privileges, you have some benefits in form of your fundamental rights. Now, if you are having some privileges, that also means that you are going to have some duties, right? Now, it's very simple that we might say that, okay, no, as a citizen, it's the duty of the government to serve the public, right? But if as a citizen of the country you are getting some privileges in form of fundamental rights, then you also have some duties towards the country, and that is something which has been given to us under part 4A of the Indian Constitution. Now, the alphabet A here indicates that it was originally not part of the Indian Constitution. It was also added in the 42nd Amendment of 1976. So the preamble was also amended in 42nd Amendment, and fundamental duties were also added through your 42nd Amendment. All right. So now that is something which you also have to understand here. That originally it was not part of the Constitution. It was made part from the 42nd Amendment, Part 4A. And Article 51A of the Indian Constitution deals with the fundamental duties. Now, what are duties you have towards your country? Respecting the constitution and national symbols, protecting the natural environment, promoting harmony and brotherhood, developing scientific temper. This way, we have 11 fundamental duties. So, you have 11 fundamental duties as a citizen of the country. Okay. Now, let us further understand this a little better. Okay, moving ahead, the next important concepts that can be tested are president, governor, and executive, which basically means we have three organs in the government: legislature, executive, and judiciary, right? Executive is one of the organs. Now, executive here includes president and governor, okay? President is the constitutional head of the entire country. Governor is the constitutional head of the state, right? And now they have a few powers. They have some powers which only they can use. First is called an ordinance making power. Now, Article 123 and talks about ordinance making power of the president, and Article 213 talks about ordinance making power of the governor. Now, what does it mean? Let's understand that. Ordinance making power here means, see, law making powers are with the parliament and the state legislative assemblies, right? And parliament and state legislative assembly, they have their own sessions. You might have heard of parliament sessions, Vidhan Sabha sessions, Vidhan Parishad sessions, right? So they're not sitting in the parliament or the Vidhan Sabha throughout the year. They're going to be sessions, right? Let's say after every 2-3 months, they have a session, and where they sit and they discuss laws and they decide upon if a law has to be made or not, right? So let's say there is a dire need for making a law. There's an urgent need to make a law or pass any rule, but the parliament is not in session, or the state legislative assembly is not in session. So in that case, are we going to wait for 2 or 3 months for the parliament to come back in the to sit and have a session, and then we'll discuss about the law? No. In that case, the president and the governor, they have the power to make temporary laws. See, otherwise they're executive, right? Executive does not have the duty to make laws, but they have some special rights, that when the parliament or the state legislative assembly is not in session, in that case they can make temporary laws in form of ordinances. Now, these ordinances, whenever the parliament or the Vidhan Sabha session happens, these ordinances have to be presented before the lawmakers. And if it becomes a law, if they pass the law, then it becomes a law. If it is not passed, then it will lapse, it will cancel. Otherwise, if it is not approved, then it will lapse within 6 weeks, right? So the basic purpose behind ordinance making power is really simple, that you can make an ordinance, or sorry, you cannot do it. I also cannot do it. The president and the governor can do it when the parliament or the state legislative assembly is not in session. Okay. Then we have pardoning power, which is there with president of India under Article 72, which says that, now let's say death penalty has been given to any criminal, right? High Court gave death penalty, Supreme Court also gave them a death penalty. Now, the president has the power to actually pardon that or maybe change that death penalty into life sentence, or maybe it can just waive off the entire death penalty also, waive off the entire punishment also. Pardoning power. Pardoning here means to forgive, right? So the president has the power to change the sentence or the punishment of a specific criminal, and that has been given to us under Article 72 of the Indian Constitution, right? So this is a power which only the president has. And third, we have the Council of Ministers. Now, Council of Ministers are also part of the executive, right? Now, you must have heard of that there is a parliament, and then there are ministries, and each ministry is headed by a separate minister, right? There is going to be there is a defense minister, there's a home minister, there is an HRD minister, there's a railway minister. So all of them are different ministries and they are being headed by different ministers, right? So all of them in together, they make a council of ministers. And the council of ministers is headed by the prime minister. So now the council of ministers and the prime minister is also part of the executive. Now, the Council of Ministers is going to aid and advise both president and governor in what has to be done in the country. And the president and governor, they are bound. It's mandatory for them to follow whatever the Council of Ministers is saying. All right. So, that is something which is really important for you to understand about the executive. Then, moving ahead, we have center state relations. Okay, now this is something very important because federalism is basic structure of the Indian constitution, right? I'm not sure if you know what basic structure is. So let's first let's understand what basic structure is all about, because I've just said this term, so I really want you to understand what it really means, right? So basic structure is really simple. See, parliament has the power to make, sorry, um yeah, so parliament has the power to make changes to the constitution, right? You cannot make changes in the constitution. I cannot do it. The parliament only can do it. But now the parliament is going to change every 5 years, right? The government is going to change every 5 years. In that case, people in the parliament are also going to change. So does that mean that in every 5 years, anybody can come and make changes in the constitution? No. So the basic structure doctrine, it says that the parliament definitely has the power to make changes, but it cannot disturb the basic structure of the Indian constitution. Now, federalism, center state relation is also part of the basic structure. Okay. Now, what does it mean now? See, the power between state and center have been divided, right? Now, state has the central government has certain roles and responsibilities, and the state government has different set of roles and responsibilities. Okay, all right. So now, what powers are there with the center? What powers are there with the state? That is something which the constitution defines, and this center state relation is discussed under article 245 to article 300, right? And it defines the power of the government. For the same, there is something called seventh schedule. Now, is there? Yeah, okay, we're going to be discussing that as well. First of all, let's discuss what center state relation here means, right? So, center state relation is part of the basic structure. Now, this is something which has been discussed in the judgment S.R. Bommai versus Union of India. This was a judgment of 1994, which said that federalism is going to be part of the basic structure. Now, I just mentioned that there is going to be separation of powers, there is going to be center state relations. So I mentioned that there is schedule 7 in the Indian constitution, which provides us three lists: union list, state list, and concurrent list. The union list, under union list, a lot of subjects are mentioned. In state list, there are a lot of subjects are mentioned, and in concurrent also there are a lot of subjects are mentioned. So the union list is really simple, right? It says that all the subjects that have been mentioned in the union list, it is going to be the central government's responsibility to make laws and policies around the same. For example, you have railways or defense or telecommunication, right? All of this is part of your union list. Then you have state list, right? Then it can be all the subjects on which the state can make laws: forest, wildlife, education, right? All of this is part of your state list. Only the state can decide and state can make laws around the same. And then there is concurrent list where both the parliament, the central government and the state government, they can function. Now there is a possibility that there might be a situation where we're not sure that which law should prevail. Now, okay, let's say there is a subject of labor rights. Okay, now some laws have been made by the parliament and some laws have been made by the state, and both of them will say that okay, we have the power to make laws because it's a subject of concurrent list. So now in that case, if ever there is a conflict that which law will prevail, so always it's going to be the law made by the central government that is going to prevail, right? So if there is any dispute, that is going to be then the current central government, then the union, sorry, central government's law will prevail, and that is also given to us under the constitution itself, which is the which is under Article 254, that if state and central laws have been made, right, under concurrent list, then the central law will prevail and state law will be void to the extent of repugnancy. All right. So, till the time, I mean, wherever there is conflict, till that portion, the state law will be cancelled and the central law will prevail. Okay. Apart from that, there is a concept of money bill, which is very important, which we've seen a lot of time being tested, right? So if you know what is the law making process is something really simple. A bill basically means a proposed law. Okay, a proposed law is presented in either house, let's say Lok Sabha, right? And then if it gets the majority, then it goes to Rajya Sabha. From Rajya Sabha, if it gets the majority votes, then it goes to the president. When the president gives the assent, then it becomes a law. Now, whenever a bill is introduced which is related to taxation, borrowing money, or anything related to finances, basically, right? Finances at central government level, at national level, then we introduce a money bill. Now, for regular laws, the bill can be introduced either in Rajya Sabha first or in Lok Sabha. But for money bill, it can originate, it can only be first presented in the Lok Sabha, right? And Rajya Sabha can only make recommendations and suggestions on the same, right? It's something really, really important. Money bill is something very important. Then, after that, a few doctrines that I would want to share with you. It's important for you to know about these doctrines under constitutional law. Why? Because I have seen them being tested. So there are few doctrines which might be part of the passage, and you might have to apply them in your in the application based questions that are there. Or if there are inference based questions also, then also you have to understand what these specific doctrines are saying, right? So first is doctrine of pith and substance, which basically means if ever there is a question that if a law is a good law or a bad law, and the judiciary has to decide if the law will prevail or the law will be cancelled, in that case, the judiciary will first of all check and see what was the objective behind this law, right? And if the law has been made with a good intent, it is going to make life for people better overall, then the law will prevail. For example, let's say Article 370 was abrogated, right? It was abrogated from Kashmir. So now there was a question that whether this amendment of abrogation of Article 370, it's a good thing or a bad thing. Now the Supreme Court, it applied the doctrine of pith and substance there, and it checked what is the purpose. The purpose was to make life of people in Kashmir better. Now, if the law works well or if it doesn't work well, that's something which nobody can predict. Okay. But with what intention the law has been made, that is something which can be tested. So the bigger goal is that life of people in Kashmir should improve, it should get better. And that's why the law has been made. So it is a valid this thing, valid amendment. Same way demonetization happened, right? So it was a question in the government, in the Supreme Court, whether Demonetization was constitutional or unconstitutional, right? So now demonetization had created a lot of issues and chaos and a lot of trouble to people. But if we use doctrine of pith and substance and if we check what was the purpose behind the law, why it was made. So it was made to eradicate corruption, it was made to eradicate fake currency in the country, right? So the purpose behind the law was clean. That's why this doctrine, the amendment or the process or the entire demonetization thing, it was not unconstitutional. Okay, so that's something which this doctrine is something based on, and the Supreme Court uses this doctrine to check if a law is a good law or a bad law. Okay, then we have doctrine of colorable legislation, which means that if the parliament, if the lawmakers do not have the power to do something directly, then they can also not do it indirectly. Now, for example, in state of Gujarat or in state of Bihar, alcohol is, these are dry states. Alcohol is prohibited there, right? So in that case, if um, the law basically says that alcohol cannot be sold and cannot be purchased directly, right? So if it cannot be done directly, then if it is being done indirectly, that is also something which is not allowed. Now let's say in form of, for medicinal purposes, maybe someone recommends alcohol to someone, right? So in that case, if something cannot be done directly, it can also not be done indirectly. Drugs, for example, are prohibited, right? Consumption of any form of drugs are prohibited. But if someone suggests that, okay, no, a certain government in a specific state, they legalize a drug which is otherwise prohibited, saying that we are allowing it for medicinal purposes. Then again, the doctrine of colorable legislation says that something which cannot be done directly can also not be done indirectly. Okay, that's where this doctrine is applicable. And a repugnancy we have already discussed. Okay. All right. Now then we have judicial structure. Now let's understand about the Supreme Court, what type of different jurisdictions and what are the different functions of the Supreme Court. So Supreme Court first of all has original jurisdiction under Article 131. Now what does it mean? Original jurisdiction, let's first of all understand what is the meaning of this term. It means that any court where the dispute will be first heard, right, will have the original jurisdiction. Now, let's say a dispute has happened in the city of Chandigarh, or let's say in city of Chandigarh it has happened. So, I am not going to go to straight away Punjab and Haryana High Court. Why? Because first of all, I have to go to the District Court of Chandigarh. And if I'm not satisfied with that decision, then I can go to High Court in form of appeal. But by jurisdiction, jurisdiction means which court has the power to hear the dispute. But by jurisdiction, District Court of Chandigarh has the power to hear the case for the very first time. So in that case, the original jurisdiction will be with the District Court of Chandigarh. Okay. Same way, Supreme Court also has jurisdiction in some cases. You cannot directly go to the Supreme Court. You cannot say that, okay, any dispute has happened here in say Chandigarh, and you cannot directly go to the Supreme Court saying that, okay, I'll just go to that court and I'll seek justice. No, you have to go to the lower court first and then to the higher court and then to the Supreme Court. That's how it works. But in some cases, the Supreme Court can be the person who's hearing the case for the very first time, right? It has original jurisdiction in what cases? Where the dispute is between states, right, or between state and center. For example, central government has a dispute with Delhi government. So in that case, who's going to hear the case? Supreme Court of India. Delhi government has a dispute with Punjab government. Two states, right? They also can directly go to the Supreme Court. The Supreme Court will hear the case. It has the original jurisdiction. Let's say state of Punjab and state of Haryana together have a dispute with state of Delhi or the Union of India. In that case, also the Supreme Court will hear the case. Okay. Then we have appellate jurisdiction, which basically means that if any high court, if you know that there is only one Supreme Court in the country and every state or multiple states and UTs, they have high courts, right? So if a high court gives any decision and if you're not satisfied with that decision, you can make an appeal to the Supreme Court. That's called appellate jurisdiction. It is under Article 136. And then we have advisory jurisdiction under 143. Now let's say the president has to discuss something. President needs some legal advice regarding any laws, any rules, and for the same, for that legal advice, it can approach the Supreme Court under Article 143, right? And the Supreme Court has to give advice to the president. Now, it is an advice, it's not an order. Since it's an advice, it's going to be the president's will, it's going to be their choice if they want to um, follow that or not, if they want to obey it or not. But otherwise, president can ask for legal advice from the Supreme Court. Okay, now that's something which has been also really important, has been tested also, right? Okay, now then we have writ jurisdiction, which I also mentioned under Article 32, right? So it says that any person who has gotten his or her fundamental rights violated can directly go to the Supreme Court or High Court to seek justice, right? This can only be done against the state, first of all, okay? Now, under Article 32, you can directly go to the Supreme Court. Under Article 226, you can directly go to the High Courts, okay? And you can file any of these writs. 5 writs you have. Let's understand the meaning of the same. Really important writs. First is habeas corpus, which means produce a detained person. If any person has been detained by any public authority, let's say a police officer has detained any citizen without any justified grounds and they're not releasing it, right? They have just been detained. So that person or his relatives or his family members, they can file a petition of habeas corpus where the court will ask the police authorities to release that person or produce that person in the court. Then we have mandamus, which means that you are forcing, where the court is going to order any public authority to perform its duty or its function. Let's say you want the municipal corporation of your area to do something and they're not doing it, right? So you can directly go to the Supreme Court and, I mean, do not go for petty matters, of course. Now, let's say some garbage and garbage collection is not happening properly, right? So for the same, you have been making multiple requests to the public authority and it's not working well. So you can file the writ of mandamus where the court is going to order those public authority to do its function properly. Then prohibition. Prohibition is when the higher court stops the inferior court from hearing any case. Okay. Then we have certiorari. Certiorari is where the higher court has the power to cancel the order given by the lower court. All right. And last is quo warranto, where you are basically challenging the public office. By what authority are they holding that office? So now let's say a person is a government officer and you think that this person has not cleared the eligibility criteria to become that public officer. So he's not the one who should be there. In that case, you can file a writ of quo warranto and you can question that by which authority is that person holding this public office, right? Now, that is something which you can use your writ jurisdictions for, all right? Now, okay, something really important are the emergency provisions. Now, emergency provisions have been given under Article 352, 356 and 360. So we have 3 types of emergency: national emergency, state emergency, and financial emergency. Okay. Now, what does it say? National emergency is really simple. If in India there is a situation where war or external aggression or armed rebellion, right, has been caused, let's say any war breaks out in India, or some really internally there is a lot of disruption of government is happening. in that case, the president can promulgate or announce a national emergency. All right. Now, then there is president rule or state emergency. If in any state there is breakdown or failure of constitutional machinery, the government probably the government has lost majority, right? The government has dissolved maybe. So in that case, directly the president will start ruling that state. Okay. Now that is also something which the uh, which something has to which the executive has to decide. And then we have financial emergency. Financial emergency is when there is, let's say, lack of money in the country, and when there are strict, financial conditions, the loan taken from international organizations, it has increased a lot. In that case, the financial emergency can be invoked in the country. So far it has never been done, touch wood, and we are hopeful that it might not happen as well. So these are the three emergencies that we have. And now let's understand what are going to be the impact of these emergencies on your fundamental rights. So whenever there is a national emergency, Article 19 is suspended, which means the six freedoms that you have, you do not have it whenever there is national emergency. Two fundamental rights which can never be suspended in any form is under Article 20 and Article 21, which Article 20 gives right to recognizes some rights of the prisoners, and Article 21 gives you right to life and personal liberty. So it says that in any situation, Article 20 and 21 can never be suspended. All right. Even during emergency, it cannot be suspended. But whenever there is national emergency, Article 19 is suspended. Okay. Okay. A few special provisions, let's understand. First, of course, is Article 370. Article 370, which provided special status to Jammu and Kashmir. So, if you remember, before 2019, Jammu and Kashmir had a different constitution altogether, right? They were not obeying India's constitution. They had a different constitution altogether. And in 2019, this article was removed, was abrogated, and now and Jammu and Kashmir was made a UT, and Ladakh was made a separate UT, Union Territory. And ever since then, there is they do not the Article 370 doesn't work anymore for them. And then we have fifth schedule. Fifth schedule talks about some special rights of scheduled areas, some tribal areas. Now, fifth schedule mentions some areas, right, some tribes, and some special rights that are available for those tribal area. Then fifth schedule do not include any area from the northeastern state, right? But then we have sixth schedule, which gives special rights to tribal areas of Assam, Meghalaya, Tripura, and Mizoram. So some special provisions have been made for these areas. And then finally we have election commission, something really important, right? Election commission is being discussed under Article 324. It is an independent constitutional body, right? It is not something which um, any government body is managing or can control. It is independent, and it's their job to get done to make sure that there are free and fair elections that are happening in the country, right? So it's their responsibility for Lok Sabha elections, for Vidhan Sabha elections, any sort of elections that happen in the country. It's going to be the responsibility of the Election Commission of India, and they're independent. They do not have to be influenced by the government. They do not have any pressure or control of the government. They're independent bodies, right? Now, there is an election commissioner which is as powerful as a Supreme Court judge. It cannot be removed. I mean, the removal process for Supreme Court judge is very lengthy, it's very technical. And same process is used for a election commissioner also, right? So it is going to be, it's very difficult for them. So they have that sort of you know, autonomy, they have a lot of power with them. So these are independent, this is an independent institution and altogether. Okay. Also, free and fair elections is part of the basic structure of the constitution that was recognized in one of the judgments of Indira Nehru Gandhi versus Raj Narayan. In that judgment, it was recognized that free and fair elections are part of the basic structure of the Indian constitution, right? So these are the areas. Now, see, the constitution is very long, it's very lengthy. There are a lot of things under the constitution, right? But still, these are the most tested areas under the constitutional law. So if you have a little bit of idea about these, it's going to be much easier for you to solve these questions and understand the principles also, and you can solve the questions quickly as well, right? So I hope you found it useful. I hope that you are taking away something important from this session. I will, if you have any questions, please put it in the chat box. Otherwise, I'll wrap the session and we'll meet again next Friday. All good? All right, if no further questions, then we'll wrap the class. Thank you so much, everyone, for joining. Have a great weekend ahead.